Yes, Mr. Kotov, he's the last case, I think, on the docket.
All right, good morning, everyone. I'm Judge Jackie Powell. This is First Appearance Court. Today, I will let you know if I've determined probable cause from the police reports I read this morning, and then we will talk about release conditions. Today is not an adversarial hearing, nor is it a trial, and so I encourage you to speak with your attorney before speaking on the record, because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by counsel from the Public Defender's Office, you need to know that in the courtroom with me, I do have one of the attorneys from the Public Defender's Office, Mr. Brian Reedy, and over at the main jail, I believe Mr. Hector Romero is there. For those of you at the other facilities, these attorneys are available to you by phone, and so if there's anything that you need to discuss before addressing your case on the record, you have that ability to speak with these attorneys. You are entitled to counsel at this first appearance hearing, and so you need to be aware of that. For those of you who are represented by private counsel, your attorneys do come to the courtroom, and they will be able to address your case from the courtroom. If your attorney's not here, you can let me know, and we will see how we can accommodate you through that process. But I ask you, as I say every morning, please don't tell me that you have private counsel unless you or your family have retained them for this recent arrest. All right? Just because an attorney represented you in the past or probably is representing you on something that's currently pending before the courts does not automatically mean that they're representing you on this new arrest today. In the courtroom with me, I also have an attorney from the State Attorney's Office, Mr. Eric Linder, as well as we will have pretrial supervision and confinement status and the clerk of the courts here this morning, and they are here to help facilitate this morning's process. They can provide additional information if needed. For some of you charged with misdemeanors or municipal ordinance violations, you may be able to resolve your case at first appearance, but that's just dependent on what's going on with you personally and other matters, if you, whether with consideration with if you have other matters pending and in circumstances such as that. For those of you who are facing felony charges, or if it's a violation of probation, most often the violation of probation already comes with a no bond hold warrant from the division judge. There's nothing that can be done about that, this judge, me, can do about that today. You will have to go before your division judge to resolve those matters, okay? All right, so the jail has asked for two persons to be called out of turn. So Nathaniel Epps, I believe, is on page 13.
Mr. Epps is here, Judge. Myself and my colleague on two opportunities asked Mr. Epps if he would like to help the public defender. Both times he declined, Judge.
All right, good morning, Mr. Epps. Sir, I just need to know that you are entitled to an attorney this morning. Are you refusing the services of the Public Defender's Office?
Yes.
Okay. You are before the court this morning, sir, for one charge of aggravated battery, and I find probable cause. And so I'll hear from the state in regards to bonds or any priors.
Your Honor, good morning. As far as priors, I'm showing trespass and resisting without violence in 2014, battery, resisting without violence 2013, trespass 05. Based on the allegations, Your Honor, state would be requesting a $5,000 bond, no victim contact.
Thank you, ma'am.
All right, so Mr. Epps, this is a second-degree felony, and I am going to impose that $5,000 bond. No victim contact, sir. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right.
Thank
Okay. All right, you're welcome. All right, and then Daniel Kotov.
He's approaching, Judge.
Okay. right, Mr. Kotov is before the court. Charge 1 is possession of drug paraphernalia. Number 2 is tampering with or fabricate physical evidence. And number 3 is a felony violation of probation. That has a no bond hold. I find probable cause. Mr. Kotov has a $1,000 bond on charge number 2. And he also has a court date tomorrow with his division judge on the violation of probation. Okay?
Judge, a photo order as well.
Okay. Photo. I think he said photo.
Yes, Judge.
Mr. Plant left the room. All right, on page 12, Eduardo Dominguez Salcedo.
He's here, present, Judge. He's gonna be, he's the only gentleman that I've spoken to that requires a Spanish interpreter.
Okay, so we'll wait for the Spanish interpreter.
Toma asiento, por favor.
And how about on page 6, Jose Vizcarrondo?
He's here, Judge. He advised me that his father has hired an attorney, and I believe my colleagues are trying to contact him.
Okay, well, we wait a few more minutes. Mr. Reedy's trying to make a phone call. Okay, let me know when you're ready. All right, Amanda Villarreal.
She's here, present. Come on up, Miss Villarreal.
All right, Ms. Villarreal, you're before the court on one charge of aggravated battery with a deadly weapon, domestic violence, and number 2 is criminal mischief over $1,000. I find probable cause. I'll hear from the parties.
Your Honor, I'm showing multiple priors out of Nevada: trespass, disorderly conduct, destruction of property. Nothing local. Based on the level of violence and the fact that a child was present in the home when this occurred, the state would be requesting a $7,500 bond on count 1, no victim contact.
Judge, Ms. Villarreal advised me as far as her out-of-state priors, most of them misdemeanors. She's 31 years old. She's been living now in our community for the past 10 years. Judge, my understanding is she is working. She works for a vacation resort. She's a sales rep, which sells vacation packages. She just got that job approximately 1 month ago. Now, I did tell her that because it's a domestic situation, the court will be ordering no contact. She will be abiding by that court order. My understanding, it was Ms. Villarreal, the person who contacted law enforcement. She's looking forward to having her day in court. My understanding, she was defending herself. Judge, I asked the court first to ask a photo order so we could photograph the injuries that Ms. Villarreal sustained as a result of the incident, which are located on her neck. But Judge, unfortunately, her phone was left at the premises, I believe, with the alleged victim. So she has no way of contacting anyone because she has no phone numbers memorized. So, Judge, at this time, the only thing we can ask for, Judge, is the court to consider releasing her on pretrial release so that she could fight these allegations from the outside, Judge.
All right, the allegations that I have before me includes that Ms. Villarreal she stabbed him with a knife, a pocket knife, and then she destroyed the GPS display screen in the vehicle of the alleged victim, in addition to other the priors that she has, Mr. Linder, out of Nevada. What are the nature of those charges?
Trespass, disorderly conduct, destruction of private property.
And how recent are those charges?
One moment, Judge. Excuse me, they range from 2011 to 2006.
Okay.
I also see, and I don't know what happened with the case, but in '05 in California, a bench warrant was issued for a failure to appear on a felony charge.
I am going to impose a $5,000 bond on charge number 1. You have a $500 bond on number 2. And I'm also ordering no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, ma'am?
Yes, ma'am.
Okay. All right. Alexandra Dominique.
No, Your Honor, she's a medical reset.
All right, Ms. Dominique is a medical reset. Emily Andrade,
Bonded, Judge?
bonded. All right.
Your Honor,
Yes.
on Ms. Dominique,
Yes.
the holds from Judge Brown are no bond, and she's scheduled to see Judge, as of right now, she has a status scheduled for Judge Brown tomorrow. My concern is, rather than resetting her to be here, that she be allowed to just go see Judge Brown tomorrow.
All right. On Alexandra Dominique, it's the 3 misdemeanor capuses, 2 with no bond holds, and 1 with a $1,500 bond. I'll leave those in place and find probable cause.
And our Spanish interpreter is present.
All right. Who needed the Spanish interpreter?
I believe there is a
This
gentleman in the main chair.
Dominguez.
Yes, Judge, on page 12. Senor Dominguez.
He also has family present, Your Honor.
Okay. All right, if you'll raise your right hand, do you swear or affirm to interpret from Spanish to English and English to Spanish?
I do.
Thank you.
María Salazar.
Thank you. All right, Eduardo Dominguez Salcedo.
Eduardo, ¿es el señor Eduardo Domínguez Salcedo?
Sí.
Yes.
You are before the court this morning.
Está usted acá hoy en la mañana en la corte.
Charge 1 is leaving the scene of a crash involving damage.
El primer cargo es irse de la escena de un choque en la que se involucraba daño a la propiedad.
Number 2 is failure to stop or remain at an accident involving injury.
El segundo cargo es que no se quedó en la escena del accidente, un accidente que involucraba lesiones.
Number 3 is failure to obtain driver's license when required.
Luego el tercero es que usted no presentó su licencia de manejo cuando le pidieron que la enseñara.
Number 4 is a traffic infraction not for magistrate.
El cuarto cargo es una infracción de tránsito que no lo ve la magistrada.
And it looks like number 5 and confinement, if you'll help me with this, because I don't have that information. Number 5 is an out-of-county hold.
El quinto cargo es una retención que le están haciendo de fuera de este condado.
That's a hold out of Orange County, I'm told.
Se me está diciendo de que esa retención de usted viene del Orange County, del condado Orange.
And Orange County has imposed a $3,500 bond on that charge.
Y por ese cargo, el quinto, el condado de Orange le ha impuesto una retención que tendría usted que pagar, una fianza de $3,500.
I find probable cause,
Encuentro causa probable.
and I'll hear from the parties.
Voy a escuchar lo que tienen que decir los abogados.
Your Honor, I'm going to be requesting a $3,500 bond on count two.
Voy a solicitar que le pongan una fianza de $3,500 en el segundo.
This is based on the nature of the offense,
Esto es en base a la naturaleza de esta ofensa.
also the nature of the offense he's on probation for.
También la naturaleza de la ofensa por la cual está usted en probatoria.
His license is currently suspended.
La licencia está suspendida en este momento, su licencia de manejo.
And I'm also concerned that he was wanted out of Orange County
Y tenemos la preocupación que a usted estaba requerido por el condado de Orange
for violating his probation
por violar su probatoria
before this alleged incident even occurred.
antes de que este incidente ocurriera.
Judge, we're gonna be asking for a $1,000 bond on count two.
Su abogado está pidiendo que la jueza le ponga una fianza de $1,000 en el segundo cargo.
Mr. Dominguez is employed, he works in construction.
El señor Domínguez tiene empleo, trabaja en construcción.
Him and his wife are raising his son right now.
Él y su esposa están criando a su hijo en estos momentos.
She works in housekeeping.
Ella trabaja limpiando casas.
They live here locally in Davie, where they rent, they do not own.
Viven acá en la localidad en David, donde ellos rentan una casa, ellos no son propietarios.
They're gonna do whatever they can to post bond, Judge, but as you can see, they have to come up with $3,500 for count five.
Ellos van a hacer todo lo posible para poner una fianza, pero como usted sabe, señora jueza, hay ya una fianza para el cargo de $3,500 del quinto cargo.
And based on my conversation with Mr. Dominguez, their financial resources are limited. That's why I'm requesting a $1,000 bond on count two.
Y en base a mi conversación con el señor Domínguez, estoy viendo su situación financiera de ellos, por eso estoy solicitando que le impongan una fianza de $1,000.
All right, ma'am, is there something you wanted to say?
Señora, quisiera decirle algo a la señora jueza.
Que él es un hombre trabajador y nosotros estamos criando 3 hijos.
That he's a very hardworking man, and we're raising 3 kids.
Yo solo quiero que él vuelva a casa.
I just want him to come back home.
Right, here's the situation that we have before us.
Esta es la situación que tenemos acá ante la corte.
Mr. Dominguez is on probation in Orange County
El señor Domínguez estaba en probatoria en Orange County.
on a charge of, it's a DUI was reduced to a reckless driving.
Era por manejar bajo la influencia, eso le fue bajado a manejo temerario.
He's on probation there, and now before the court is that he's violated that probation.
Y él estaba en probatoria en ese cargo y ahora está ante la corte por violación de esa probatoria.
So there's all indication that Mr. Dominguez knew that he should not have been driving.
No hay ninguna indicación de que él no supiera que no podía manejar.
And so the allegations that are before the court today
Entonces, los alegatos que tenemos acá ante la corte hoy,
is that he was driving and that there was a crash.
de que él sí estaba manejando y hubo un choque.
And so based on those allegations this morning,
Entonces, en base a esos alegatos esta mañana,
on charge number 2,
en el segundo cargo,
I am going to impose a $3,500 bond.
voy a imponerle una fianza de $3,500.
All right, the other charges don't require a bond, and so I will not impose one on those other charges.
Y los otros cargos que él tiene no requieren fianza.
All right.
Es la única que va a poner.
Thank you.
All right. Is there anyone else who needs a Spanish interpreter?
¿Alguien más que necesite el intérprete?
Not here at Maine, Judge.
Not anywhere else as far as I know, Judge.
All right, thank you. Okay. All right, Robin Reynolds.
Yes, good morning. Good morning, Judge.
Miss Robin. Good morning, Miss Reynolds.
Good morning, Ms. Powell, Judge Powell.
You are before the court this morning. Charge 1 is possession of cocaine. Number 2 is attaching a registration license plate not assigned. Number 3 is a violation of felony probation. That probation is before Judge Scher, and it has a no bond hold. So you will see Judge Scher tomorrow at 8:30 a.m. I find probable cause, and I will leave the bond on 1 at $1,000, okay?
Good luck, Robin.
Thank you.
Okay. All right, India Graham.
Also North Broward, Your Honor.
See.
Yes, ma'am.
Ms. Graham, you're before the court. Charge 1 is displaying a firearm during a felony. Number 2 is possession with intent to sell, manufacture, or deliver cannabis. Number 3 is possession of cocaine. And number 4 is possession of heroin. And I find probable cause for these charges.
Judge, I'm going to be asking for a pretrial release for Ms. Graham. It's my understanding from what she has told me that she does have a permit, a carrying concealed firearm permit. It is in the vehicle. And she attempted to bring that to the officer's attention, but apparently the officer was not inclined to listen to what she had to say. She has been living here in Florida since February at the same location. She does have a job. She works as an independent contractor with a construction company. She does have contact with the criminal justice system, but I believe it's years ago. She is a veteran of the U.S. military. She was in the Army from 2014 through 2016, and she received an honorable discharge.
I don't know why it's being said that the officer didn't listen. She's not charged with carrying a concealed firearm. Whether she has a concealed permit or not, she's not supposed to be in possession of a firearm or on the commission of a felony offense, which is what she's charged with. As far as history, Your Honor, she went through diversion in Palm Beach County in 2017 for prostitution.
Wasn't even my fault. I got expunged, by the way, Your Honor. It wasn't my fault.
Just for the record, since it was brought up, Your Honor, in my system, it shows when something has been sealed. I'm not saying that it's not sealed. It just doesn't indicate it was, because if it did indicate that, I wouldn't have even brought it up.
Okay.
So it would seem that her contact with the criminal justice system is minimal, Judge.
I understand that, but we have 3 different types of drugs and a firearm. So at this point in time, I am going to impose $1,000 bond on 1, and the other counts have $1,000. All right. On page 15, Jarvis Lawrence. Yes.
Jarvis Lawrence? Jarvis, page 15?
Yes, it says page 15.
One moment, Judge. He should be here. No, or is he in back? Oh, was that the front? Oh, no, here he is.
Your Honor, while
He's coming up, Judge.
it's coming up, it looks like this should be a burglary of a conveyance.
Yes. All right, Mr. Lawrence then is before the court. Charge one is burglar of a conveyance, and number two is a felony violation of probation with a no bond hold. I'm just making the correction on the determination to reflect conveyance. I find probable cause.
Judge, considering one is a third-degree felony, I do understand he has a no bond hold on count two. I'm gonna be asking for $1,000 bond. You'll be seeing his judge tomorrow.
Your Honor, I'm gonna be requesting a $3,500 bond. He's on probation for one grand theft. That he was qualified as a habitual offender on that offense. He was sentenced to 364 days county jail and another grand theft earlier this year. Criminal use of personal identification information, 2018 VOP. Unlawful use of false name ID, 2014, theft, 2011. Grand theft auto, 09, VOP, 18-month state prison. Two more grand theft autos in 09, violated probation, 18-month state prison. Burglary of a conveyance, 08, VOP, 18 months. Grand theft auto, 07.
Morning, ma'am, is there something you wanted to say?
I'm small, ma'am. He's lived with me, and I'm working at Crowns Plaza. I'm practically late, and he's been doing very well. He's had like probation. He's got one more month on probation. I take him every month to the probation office every month. He's lived with me. I make sure he do the right thing, but he probably was at the wrong place at the wrong time. But he's in my care and everything. And I'm sickly. He does help me out, you know. But there's so much I can do. I need him. And I'm just here for him. He's been doing the right thing. I've been taking him to the probation office myself. He had like 1 month left, paying restitution, whatever. Taking care of 2 kids of my own, little teenager girls of my own. I'm headed to work right now.
I can hear you, and I have no doubt that you're trying to help your son. But at some point in time, he's 30 years old, he's gotta start helping himself,
Absolutely.
all right?
Yes, ma'am.
So you've
he's
been,
been doing that, ma'am.
you've been obviously been a mother who's been helping, but today he is before the court on another charge of burglary of a conveyance. And it is, not only is it alleged, it is also alleged that post Miranda, he had admitted to what was going on here, right? I am going to impose a $2,000 bond on one. He does have a no bond hold on the violation of probation, so he has to go before his division judge tomorrow on that charge, okay? It's at 8:30. Which judge is this? Judge Yuson,
Thank you, Judge.
okay?
Thank you, Judge.
All right. On page 15, I have another sign-in for Ronald Pinkney,
Mr. Pinckney, come on up, please. He's approaching, Judge.
okay? Good morning. Mr. Pinkney is before the court. Charge one is selling cocaine, and 2 and 3 are violation of probation. And looks like you're on probation with Judge Merrigan. And so you also have 2 no bond holds. You will have to see Judge Merrigan tomorrow at 8:30 a.m., okay? I find probable cause, and I'll hear from the parties. He already has a $15,000 bond from the warrant with special conditions. I was gonna leave those in place. I don't know if there's something else that,
I don't have any additional requests, Judge.
all right?
Nothing from the defense based on his no bond holds, Judge.
Okay, all right, thank you. All, let me borrow the picture per confinement. All right, Courtney Hardy.
Judge, she's approaching. She declined the services of public defender. She's going to represent herself.
All right, Ms. Hardy, good morning.
Good morning.
Ma'am, you understand that you are entitled to an attorney for this hearing today? Do you understand that?
Yes, ma'am.
And you are declining the services of the Public Defender's Office, is that correct?
Yes, ma'am.
Or you plan to hire private counsel?
Yes, ma'am.
Okay,
Not right now.
okay. All right, you are before the court this morning. Charge 1 is grand theft auto. Number 2 is a felony, it's a violation of probation, which has a no bond hold for Dade County.
Yes, ma'am.
And then number 3 is altering a license plate, which is not from magistrate. I find probable cause. And ma'am, you have $1,000 bond on 1. I'm going to leave that in place. And like I said, number 2 is a no bond hold for Dade County, okay?
Yes, ma'am.
All right.
Thank you.
You're welcome. All right, Mr. Plant left the room again. And what were we waiting for on Mr. Viscarando? I don't remember.
I think his attorney's present now.
We're waiting for, oh, okay. Okay,
Mr. Viscarano?
sure. Wait,
Your private attorney's there?
Yes, sir, thank you. There was gonna be, their family is on the way, Judge, just to let you know, but I'm prepared to give the court and the state some information. State, does he have any, priors?
Well, I mean, before we get into that, I mean, are we gonna?
all right.
Just,
Do
before I
you,
argue, I wasn't
do
sure
you
what his
want me-
background
No, I know.
okay, are we waiting for the family? Because someone had signed in before and had called it before.
If the court has time and patience, I can
I have no problem. Someone was here before and I called it, and that's when they told us that he had private counsel, so. I don't know where they went, but someone had signed in before that says his mother or something. That was here this morning. I can
could-
wait.
If you could pass it, do you have other cases?
No problem.
Thank you, ma'am.
All right. Pamela Mendez Estrella.
She's here, Judge at Maine.
All right, Ms. Estrella is before the court this morning. Charges 1 and 2 are a felony violation of probation. This is probation with Judge Weeks, and those 2 charges have no bond holds. And then there's a traffic capias, and there's a $500 bond. I find probable cause, and you will see Judge Weeks, it looks like tomorrow, and then on the capias, you'll see that division judge on the 16th, okay? Alyssa Rubio.
Ms. Rubio is approaching, Judge.
Good morning.
Good morning, Ms. Rubio. You are before the court this morning on charges 1 and 2 are aggravated assault with a deadly weapon without intent to kill. Number 3 is criminal mischief under $1,000, and I find probable cause.
Excuse me. Your Honor, I see no history. That being said, I'm gonna be requesting a $5,000 bond on count 1 and 2, no victim contact, no possession of any firearms, weapons, or ammunition. Concern based on the allegation that she brought a butcher knife to a location where she threatened the 2 alleged victims.
Okay?
Judge, as you heard correctly, Ms. Rubio has no prior contact with the criminal justice system. She's a registered voter in our community. She's been here her whole entire life. She is 20 years old. She's currently working. She works for Allstate as a sales rep, been there for about 1 year now. She lives locally in Hialeah with her 2-year-old daughter. Right now, her daughter's being taken care of by the daughter's grandmother, her mom. My understanding, Judge, is I believe this incident took place a couple days ago. My understanding, Judge, is Ms. Rubio basically contacted law enforcement, told them as far as what happened. My understanding is she went to the actual Davie police station yesterday voluntarily on her own, was taken into custody. She's adamant as far as looking forward to having her day in court. She was defending herself, Judge. My understanding, Judge, right now, $10,000 is something a little bit beyond her means. We were going to be asking the court to consider $1,500 on count one, $1,500 on count two, Judge, and a photo order as well.
All right, with the no priors, I am going to impose $2,500 bond on 1 and 2. No victim contact. Based on these allegations, it appears that Ms. Rubio, I think if I heard correctly, she lives in Hialeah. She went to the alleged victim's home in Davie, and not only did the allegations say that she threatened the two persons with a knife, but that she also broke the front window of the living room after the whole incident. All right, Jasmine Gallego.
Ms. Gallego is here present, Judge.
All right, ma'am, you are before the court with one charge of burglary with assault or battery. And I find probable cause.
Your Honor, I am going to be seeking a finding of proof evident or presumption great, and that Ms. Gallego be held no bond for first appearance purposes. I am concerned. The allegations that she broke into her boyfriend's home, armed with a knife. She threatened two individuals, cutting her boyfriend and threatening the other woman that was there. As far as the strength of the evidence, I would note, and the officer notes, that this was recorded. The defendant recorded this on Facebook Live. She made admissions to cutting the boyfriend, stating that she would stab him again. Your Honor, it would appear, one moment. Also noting, Ms. Gallego made an admission that she does not reside at the location. She'd been gone for a while, and the black and orange knife that was used was located and recovered.
Okay.
We would object to the court making a finding of proof evident presumption great at this stage of the proceedings. Obviously, there's two sides to every story. Ms. Gallego's side of the story is not probably going to be told today, but this does look like there was a pre-existing relationship. I noticed that the victim, according to the report, received a small laceration to his right wrist. I'm sure that Mr. Romero has explained to Ms. Gallego that if she is to be released or to post bond, that she is to have no contact with any of the individuals involved in this incident and to stay away from them. So I would first state, there's a video of this entire incident, which the state has decided not to present to the court this morning, which would look as though that would be evidence I would think the court would want to see before making a finding of proof evident presumption great. In light of the fact that the state has produced no evidence and called no witnesses, we would urge the court not to make a finding of proof evident presumption great, or if making such a finding over our objection, that the court exercises its discretion and sets bond for Ms. Gallego.
All right, based on the allegations, the officer does refer to the the Facebook Live recording and states that on the recording, the defendant is heard saying that I'm recording you, and then look at where this hoe is laying at, and the person who's later identified is heard in the background saying, "Put the knife down," and with colorful language, she said that she's not putting the knife down, and then there are allegations that I will stab you again. So,
If I may just point out one more thing, Your Honor.
yes,
According to the police report, the victim indicated that he was uncooperative and advised that he was not stabbed and just wanted Galejo and Jackson to leave his home.
right, and but there was blood on his arm. That's also there, all right? So, with the information that I have before me this morning, I am, going to make a preliminary finding of proof evident presumption grade. Ms. Gallego will be held no bond. This is without prejudice for you to have a bond hearing before your division judge, okay?
Before she leaves,
Ms. Gallego, I'm also directing you that you are to have no contact with any of the alleged victims in this matter. It means no phone calls, no text messages, no social media, no third-party contact. Do you understand that?
Yes, ma'am.
There will be a 500 feet stay-away order if you post your bond, if a bond is given later on and you post your bond. Do you understand?
Yes.
Okay. All right, Jacqueline Nebellini.
No fraud, Your Honor, she's a medical reset.
All right, Ms. Nebellini is a medical reset. Samuel Polk.
Please approach the judge.
Mr. Polk is before the court on one charge of aggravated battery. Offender knew or should have known that the victim is pregnant. I find probable cause for this charge.
Your Honor,
Yes, ma'am.
he's currently on pretrial in two separate cases. Case number 1815289 CF10A for possession of a weapon by a convicted felon, and case number 193714 CF10A for possession of a firearm by a convicted felon, aggravated battery with a deadly weapon, and aggravated assault with a deadly weapon. Pretrial is asking that you revoke his pretrial in those two cases. He was placed on in division on August 2nd.
All right, based on pretrial's request, I am going to grant the revocation of pretrial supervision. That's on case number 18015-289 CF10A. There, that charge is possession of a weapon by a convicted felon. I'm gonna revoke pretrial, and he's going to have a $2,500 bond. Yes,
Did he have his pretrial revoked on that case as well? It was just the other one.
before?
No, I know on two. Your Honor, I'm asking, on the aggravated battery case, this would
Yes.
be from what I can tell, the second time he violated it. And I was just asking pretrial if she knew on the other case which you are addressing first, if this would be his first violation or not.
He was violated in May. He was violated in March. He was violated in February.
All right, case number 18015-289 CF10A. I'm granting the revocation with no bond hold. And case number 19003.
Judge?
Yes,
Mr.
I didn't
Keating,
violate, they refiled the charges and and brought me in and put me back out, but I didn't violate. I would like to have a bond, Your Honor. I didn't violate in February. They refiled the charges and upped them, and then they let me back out, Your Honor.
They're not talking about February, she's saying in March and May.
Yeah, that's when they let well, wherever they came and got me and refiled and upgraded the charges on me and put another charge and let me back out.
Your Honor,
I didn't want to get them. I would like for you to give me a bond on these. I'm working, and this charge that just happened. I can't talk about the case, Your Honor, but this didn't happen like what they saying happened. I didn't even see nobody this night. I'm begging that if you allow me to have a bond on them two charges, Your Honor, I will come to court. I've been coming to court. They was going to resolve it, throw it out. They've been saying they're going to throw it out, but every time I go to court, they set me off. Now this happening. I just got my license, got a good job. I just got a home, man. I'm asking you, and I'm asking the state if they can just agree upon a bond that I can have on these two charges, and I can bond out them. I promise you that I am trying my hardest. I am doing everything I got to do with this case.
Well, I know
the
you
state-
came before me for your first appearance. And obviously I set a bond. You went to your division judge and the judge puts you not on, without monetary bond, but to be on pretrial.
And they
So,
filed the charges again.
okay,
and they-
please stop talking for a moment. Yes, Mr. Linder.
Your Honor, and I can confirm, I checked Odyssey, this would be his third violation. Judge Shear signed two previous warrants for violating pretrial.
All right, so I'm
And
holding
Judge,
you,
my understanding on the new law offense, hold on, sir. On the new law offense, it's nothing similar to what he's currently on, pretrial for. My understanding, this is his first domestic situation. What I'm gonna be asking the court, Judge, is to consider something, as far as holding him no bond, that's probably the most severe sanction the court can impose. I'd ask you at this time to consider something less, restrictive, maybe a monetary bond with level 2 so that he can fight these allegations from the outside, Judge.
I'm going to deny that. Again, folks, Mr. Polk is before the court on 3 charges now, 2 violation of probation, where he violated probation twice. The charges are possession of a weapon by a convicted felon, possession of a firearm by a convicted felon, aggravated battery with a deadly weapon, aggravated assault with a deadly weapon, and today he's before the court on aggravated battery. All right, so I am granting pretrial's request to revoke the pretrial, 18015289 CF10A. He'll be held no bond until such time that is heard before his division judge, and also case number 19-003-714 CF10A. I am granting the revocation. He'll be held no bond.
Honor, on this offense, considering he's out on 2 cases, both alleging unlawful possession of a firearm, one act of violence, and now he's here with another alleged violent act, I'd be requesting a $10,000 bond, no victim contact.
And Judge, we're gonna be asking for a $3,500 bond. Once again, Mr. Falk is advising me or denying these allegations. He's looking forward to having his day in court. My understanding, he has no prior domestic convictions. So Judge, we're asking for a $3,500 bond on his behalf.
All right, on the new charge, I'm imposing a $5,000 bond and no victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Okay? All right, Brenton Brammer.
Hello. Good morning.
All right, Mr. Brammer's before the court. 1 charge of aggravated battery. Offender knew or should have known that the victim is pregnant. I find probable cause.
We're ready to proceed, Judge. Initially, he declined, but he changed his mind. He wants our help, so.
Okay,
Your Honor, state would be requesting a $7,500 bond, no victim contact, no possession of firearms, weapons, ammunition. This is based on the allegations in this case that the victim is currently 8 months pregnant at the time of this incident. Also noting that Mr. Brammer was arrested in 2018 for domestic violence battery against the same alleged victim, and that was dropped late January of this year.
Judge, under the circumstances, that's reasonable. We're in agreement with the state.
All right, I am going to impose a $10,000 bond. No victim contact. No phone calls, no text messages, no social media, no third-party contact. All right, I know Mr. Nanda is still on medical loan.
Yes, ma'am.
Steve Shell,
He's approaching.
Mr. Shell is before the court. Charge 1 is assault on an officer. Number 2 is assault. Number 3 is resisting without violence. Number 4, resisting without violence. I find probable cause. Mr. Shell has a $100 bond.
Nothing to add at this time, Judge.
Okay,
Just, one moment.
just no return to that location where the incident occurred, okay? All right,
I'll contact your sister.
Craig Strong,
Mr. Strong, North Broward, Judge.
North Broward. How you doing, ma'am?
I'm well, Mr. Strong. You are before the court this morning for one charge of trespassing, and I find probable cause.
No, Mr. Strong had expressed a desire to resolve this case this morning.
All right, state you have an offer for Mr. Strong?
One moment. Your Honor, the state's offer would be an adjudication 5 days in county jail, no return. I confirmed what the officer wrote in this report. This would be his third arrest in this area, this development this year. This is a residential property.
All right, and so he pled out 2 prior cases?
Yes, Your Honor. One was a trespass actually, he was arrested in April, ended up pleading out in May. The other was a loitering and prowling. And one moment. Let that out in May also.
All right. All right, Mr. Strong, based on the time, you have 2 prior incidents at this similar location, I am going to, it's gonna be 5 days in the Broward County Jail if you take the plea today.
If I take what plea today, ma'am?
That's, if you want to resolve your case today, this is what your attorney said, your sentence will be adjudication and 5 days in the Broward County Jail.
Ma'am, I wasn't trespassing.
All
I was
right.
just crossing.
All right, sir, I am not going to argue with you. This is a $25 bond. I'll leave that in place, okay? Vinda Ramkelawan.
He's approaching, Judge.
All right, Mr. Ramkelawan is before the court on one charge of touch or strike battery. And I find probable cause.
Judge, I'm speaking with this gentleman. He's not in a position to call anyone to post any, his monthly bond. He's been residing in our community for over 5 years. He's 34 years old. He lives in North Lauderdale with his fiance. My understanding, he works at the swap shop, specifically at the T31 booth, which is located inside the tent covered area. Judge, he's looking forward to contesting these allegations. He will be coming back to court, but right now he can't afford to postpone, so we're asking the court to consider releasing him under pretrial release.
I'm asking the court to keep bond $1,000. I understand he wishes to he's looking forward to contesting this, but according to this, there's surveillance video that captured the incident and an independent witness that gave a sworn statement. I'm showing Mr. Ram Kelawan has a permanent injunction order of protection in place from 2015 and a carry and concealed firearm offense in 2015 as well.
All right, finding probable cause, he has a $1,000 bond, okay? Francisco Valdez Villacres. All right, Mr. Villacres is before the court. Charge 1 is exposing sex organs in public. Number 2 is trespassing, and I find probable cause.
Well, Mr. Valdez did indicate to me, Judge, he'd like to resolve the matter today.
Yeah, but I think
But I think maybe Judge Lerner Wren might be in a better position to deal with this.
Just so the court's aware, in 2016, he was picked up on the same offense, and it ended up being resolved, but he did go through Judge Lerner Wren's division.
All right, I'll sign an order for a judge to transfer to Judge Lerner Wren. All right, sir, you'll see Judge Lerner Wren shortly. All right, Dennis Smith.
okay. Thank you.
He's approaching, Judge. He's here at Maine.
All right, good morning, Mr. Smith. You are before the court this morning, sir. Charge 1 is petty theft, and charges 2 and 3 are capuses, and those capuses have $500 bonds attached to them. One was issued September 18th. The other one was issued September 24th. Looks like Judge Schiff on both of them, okay? I find probable cause.
Judge, Mr. Smith wishes to resolve these matters today.
State's offer to resolve all 3 cases would be adjudication 7 days county jail. This would be his 2nd and 3rd theft resolved this year.
Say 2nd and 3rd?
2nd and 3rd thefts. He resolved a petty theft earlier this year.
Judge, we have an agreement. Mr. Smith wishes to
Oh,
accept
I
the state's
see,
offer.
because one of the charges is a petty theft.
Well, two of them. 1 and 2 are
Today, 1 and 2,
petty
yes.
thefts, and I could have put it better.
I understand. All right. So he wants to accept? He understands if he gets another petty theft, he'll be charged as a felony?
I did advise him of that, Judge.
Okay. All right, Mr. Smith, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Okay, sir, you can put your hand down. And do you understand everything we've discussed here today?
I do.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, I'm satisfied.
You understand, that's good to know. You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
I do.
All right, and have you ever been treated for mental or emotional illness?
Nah, I take mental health medication.
Is there anything about those medications that you take that would prevent you from making a decision today?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I understand.
What plea do you wish to enter at this time, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence today, sir, 7 days adjudication, 7 days in the Broward County Jail. all three charges to run concurrent, okay, with credit for any time served. All right, Whitcliffe Shields,
Mr. Shields is here, present, Judge, come on up, sir. And Judge, he wishes to represent himself.
okay?
Judge, he changed his mind, he's gonna be with the public defender.
All right. All right, Mr. Shields is before the court. Charge 1 is touch or strike battery, and number 2 is criminal mischief, and I find probable cause.
Judge, Mr. Shields advised me he could contact his mother to post his bond. Unfortunately, he forgot his mom's number. He doesn't have it memorized. He doesn't have his phone here on property. So at this time, we're going to be asking for the court to consider releasing him under supervision on these misdemeanor offenses, Judge.
All right, state?
I don't see any history, Your Honor.
No history?
No.
Okay. All right, Mr. Shields, I'll release you to pretrial supervision. And sir, you need to report to the pretrial office no later than tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that, sir?
Yes, sir.
And then the next thing is no victim contact, which means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, sir.
Okay. All right, Kevin Furlong.
He's a medical reset, Your Honor.
Thank you. Mr. Furlong is a medical reset. Joseph Reyes.
He's here, present, Judge. Jermaine.
All right, Mr. Reyes, you are before the court this morning. This is an ad charge for grand theft. And the date of this incident is April 26th of this year. And I find probable cause.
Judge, my understanding, Mr. Ray has been in custody now almost 5 months. He completed a 270-day sentence. I believe his completion date was yesterday. This is the only thing holding him. Judge, my understanding is if he gets out, he will be getting a job as a hairstylist. He's going to live here locally here in Coral Springs, but unfortunately, there's nobody that can post his monetary bond. This date of offense, as you said, happened in April. We're asking if the court would consider releasing him ROR or on the alternative on pretrial release.
I don't have an objection to pretrial, Judge.
All right, I'll grant the ROR to pretrial and no return to,
I'll look it up.
it says Sephora, but I don't know if it's in a mall or if it's a freestanding store. So no return to that Sephora. Sir, you need to report to the pretrial office no later than tomorrow morning. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay,
Good luck, sir.
thanks. All right, Jimmy Mathis.
He's approaching, Judge.
All right, Mr. Mathis is before the court on one charge of drug paraphernalia, possession of drug paraphernalia. Number 2 is tampering with or fabricating physical evidence. 3 and 4 are violation of felony pretrial. Those already have no bond holds and are not for magistrate. I find probable cause, and he has a $1,000 bond on 2. Okay. Mikos Milton. Mr. Milton is before the court, charge 1, driving while license suspended, third or subsequent offense. Numbers 2 and 3, felony violation of probation with no bond holds. And I find probable cause. I don't have a date when you'll see Judge Scher, but I suspect it'll be shortly.
Tomorrow at 8:30, Judge,
Okay.
according to my docket.
All right, so he has a $750 bond on one.
Judge North Broward is called. They're asking you to take a case out of turn.
Which case is
It's the
that?
very last case on this morning's docket, Mr. Cambrell Morris,
Okay,
Morss.
all right, Cambrell Morse. All right, Mr. Morris is before the court. Charge one is possession with intent to sell, manufacture, or deliver MDMA. Number two is resisting officer without violence. Number three, driving while license suspended. Number four, attaching registration license plate not assigned. And then number five is a felony violation of probation. This is probation before Judge Lynch, and Judge Lynch signed a warrant for a no bond hold. So you will see Judge Lynch tomorrow at 8:30 a.m. I find probable cause. You have a $2,500 bond on one. Okay?
Okay.
All right, Arnaldo Abreu,
Thank you, Your Honor.
you're welcome.
He's approaching, Judge.
All right, Mr. Abreu is before the court. Charge one is possession of THC, and number two is driving while license suspended without knowledge. That's not for magistrate. I find probable cause.
Judge, at this time, on this possession THC, I'm going to ask the court to consider releasing Mr. Abreu on straight ROR. My understanding is he's a registered voter in our community. He's been here almost his whole entire life. He's 24 years old, been here 22. He's attended Northeast High School, graduate in the class of 2013. He's working right now. He's living here locally in Margate. He will be coming in court. It's not a flight risk. And that is why I'm asking for a straight ROR on this nonviolent offense, Judge.
All right.
Let's see any history.
Okay, all right, then I'll grant the ROR at this time. And Mr. Abreu, you need to make sure you stay in touch with your attorney so that you'll know if you have to come back to court, okay?
Yes, ma'am.
All right, Jeremy Natal, Mr. Morris, are you ready? All right, Mr. Natal is before the court on one charge of aggravated assault with a deadly weapon without intent to kill. Number two, aggravated battery. I'm just handling this one before yours. I wasn't sure. Number three is carrying a concealed firearm, and number four is possession of cocaine, and I find probable cause. All right, state.
Let's see if there's any history. Your Honor, I'm going to be requesting a $10,000 bond on one, $10,000 bond on count two, no victim contact, pretrial release of the GPS monitor. I'm very concerned, based on these allegations, that he threatened one individual with a firearm, that he attacked another individual, breaking the victim's jaw and nose, requiring reconstructive surgery. Noting that was caught on surveillance footage.
And does he have any priors?
He has juveniles, nothing related to this.
Okay.
That's what Mr. Natal advised me, Judge. He basically has a clean adult record. He's a registered voter. He's 20 years old. He is working now. He works for a company called DNA Transport. It's a moving company where he's been employed there for about 1.5 months. He gets paid daily. He gets paid about $120 a day. Now, he does have family that lives in our community. Specifically, he's going to be reaching out to his brother to help post his monetary bond. My understanding is his brother works at a wheel tire shop, so his financial resources are limited. We were going to add, we understand the nature of the allegation is serious, but we're going to be asking for a $5,000 bond on count one, $5,000 bond on count two, and a photo order as well, so we can photograph the injuries Mr. Natal sustained.
All right, I'll sign that photo order. I am imposing a $5,000 bond on one, $10,000 bond on two. The other standard bonds will remain in place, and no victim contact.
And it also has no possession of firearm.
And no possession of any weapons or firearms.
Yes, ma'am.
All right, Mr. Morris. Jose Vizcarrondo on page 6, Mr. Romero.
Your Honor, thank you for your patience and indulgence.
I'm sure your private's right there.
Yes, page 6, Jose Vizcarrondo, and Mr. Vizcarrondo is before the court on one charge of aggravated assault with a deadly weapon. Number 2 is touch or strike battery. Number 3 is touch or abuse of child without great bodily harm.
All right, just to check with the state, it's my understanding that the child abuse is because children were alleged to have been present,
That would appear to be the
but
case.
he did not
Right.
strike any child. Just want to make sure from the affidavit. I didn't see anything that indicated that.
Right. That is correct. All
Okay.
right, I find probable cause.
Yes, Your Honor. Mr. Vizcarrondo has strong ties to the communities, and he's a U.S.-born citizen, lifelong resident of Broward County. He's full-time employed at a barber shop on 163rd Street in Miami-Dade County. According to the state, he did have one contact or an arrest in Dade County. I don't know what year, but there was no disposition on that. Apparently, it was dropped, so he does not have any priors for the court. Again, he has strong family ties to the community. He is not a risk of flight, and not minimizing at all the seriousness of these charges. I don't believe, based on having no priors, that he is a danger to the community. What we're asking, because money is sort of tight, that the court consider at least a standard bond, but if the court can come down a little bit and maybe combine that with pretrial, that would be something we would ask the court respectfully to consider as well. But, and there's one other thing, Your Honor, and I don't know if the state picked this up, but I think the court needs to be aware, and we need to straighten this out. But on the first page of the complaint affidavit, when we look at the name of victims, we have a different address for Ms. McFarland, who is the alleged victim. It's different than the location that was listed as the arrest location. So if the court, I assume, is going to order a stay-away order, I think the state and the defense need to understand who lives where so that they can not, so my client doesn't run into any situation where he's violating any type of stay-away.
Your Honor, I'll address the last issue first. I'm just going to be asking for no contact. It really doesn't matter. I mean, for all I know, this woman may move tomorrow. She may move to another location 2 weeks. Wherever she resides, I imagine the court, if the court issues no contact, it applies to wherever she resides.
Are they alleged to be, are they living together?
No, they are not, Your Honor. They have one child that's, one biological child, but there is another child that Mr. Vizcarrondo also
Right.
supports.
So if they don't live together, so then there should be no problem with the no victim contact.
Understood, Your Honor.
Okay, all right.
The prior arrest that counsel was referring to was a 2017 domestic violence battery out of Dade County against a different alleged victim that was dropped. I do have safety concerns, Your Honor, noting, and I'd also know Mr. Vizcarrondo admitted to striking the victim with his hands, pushing her to the ground, and this was because she didn't come home right after work and because she wasn't answering her phone. that level of hostility and anger causes me concern, also considering that there were two children in the room where this occurred. I'm going to be requesting a $7,500 bond on count 1, a $2,500 bond on 2, and a $2,500 bond on 3.
I would ask the court to please consider a standard bond, especially on the misdemeanor battery. And not to minimize any of the seriousness of this, but his family is present. They offer strong support for this individual, for my client. And again, money is tight. I understand the state's concern, but he is not a risk of flight. And he has never shown by any contacts with law enforcement that he is a danger to the community at large.
Right, I am going to impose, well, this is going to be with pretrial. All right, so he's going to have a $2,000 bond on 1, a $1,000 bond on 2, a $2,000 bond on 3, including pretrial supervision. No victim contact. That means, again, no phone calls, no text messages, no social media, no third-party contact. There will be a 500 feet stay-away order, and no weapons or any firearms. Do you understand that, sir?
Or just so we,
Did he indicate that he understood it? Speak into the microphone.
It wasn't on.
Okay.
Okay.
just to clarify for going forward, the no victim contact, does that apply to EM or EM and both juveniles?
To the adult. How about
Okay,
that?
okay.
Okay. All right, so the no victim contact is to the adult, okay?
Yes.
Just
And ma'am,
standard
thank you
pretrial.
very much for the court's indulgence, and thank you to your staff as well.
You're welcome. All right, Darnell Paul.
Mr. Paul, come on up, please.
And was this? Yes, Your Honor, we had his co-arrestee earlier. Again, I think this should be burglary of a conveyance.
All right, Mr. Paul is before the court on charge 1, burglary of a conveyance is number 1. Number 2 is criminal mischief. And then 3, 4, 5, and 6 are all felony cases with no bond holds, and those are not for magistrate. So I find probable cause.
Judge, considering his no bond holds, we're asking for a $1,000 bond on count 1, which is third-degree felony.
Your Honor, set a bond on a $2,000 bond on Mr. Lawrence with the pending VOP. I'd ask for the same bond.
All right, so he has $2,000 bond on 1, and he'll see his division judge tomorrow at 8:30 a.m. Thank you, ma'am. All right, Jonathan Mason.
Mr. Mason's approach, Judge, you start me.
All right, Mr. Mason is before the court. Charge 1 is on 1 charge of grand theft, and I find probable cause.
Judge, Mr. Mason informed me, he can't afford to post a monetary bond, nor anyone he knows. Right now, he's currently looking for work. He's living with his brother-in-law in Fort Lauderdale while he gets on his feet. My understanding is brother-in-law gets Social Security, so he can't afford to post a monetary bond. He's been here his whole entire life, Judge, so we're asking him to be released under supervision of pretrial.
Any,
One moment, Judge. Your Honor, Mr. Mason was released from state prison in 2018 after being sentenced to 3 years in state prison as a habitual offender for burglary of an occupied dwelling. That was a 2015 case. Theft 2012, theft 2012, multiple drug priors, and in the early 90s, 3 separate robbery firearms, 6 years state prison.
All right, Mr. Mason has a $1,000 bond, which I'm leaving in place at this time. Jean BME,
Mr. Benamy, come on up, please.
Good morning, Judge.
good morning, sir. You are before the court this morning. Charge 1 is selling heroin, and number 2 is selling fentanyl. All right, and I find probable cause. This is from warrant that was already signed. And I find probable cause. All right, as to bond,
Your Honor, one moment. State is going to be seeking bond in the amount of $7,500 on each count, pretrial release with a GPS monitor. Mr. Bienemy is out right now on bond. He is out on a total bond of $4,000 for possession of firearm by convicted felon, carry and conceal firearm, and possession of cocaine. He bonded out mid-December of 2018. The case is before Judge Scheer, and the state in that case has filed a notice to declare Mr. Bienemy a habitual offender. Additional prior out of Broward, 2007, aggravated assault with a firearm, false imprisonment and battery. He was violated probation and was sentenced to 10 years in state prison as a habitual offender, released in October of 2016. He's also been to prison for aggravated assault, sale, delivery of cocaine, possession of cocaine, sale, delivery of cocaine, trafficking cocaine. Nothing further, Judge.
Judge. Judge, we're going to be asking if the court would consider setting a bond in the neighborhood of $3,500 on each count. Now, he's been here almost his whole entire life. He's self-employed as a photographer. It depends on, as far as his salary, depending on the number of jobs he's given. But on an average, if things go well, he can make about $500 a week. He lives locally here in Fort Lauderdale in a duplex with his mother. His mother works. She's a housekeeper. My understanding, Judge, as the state did bring up, he's out on a case. My understanding is he's already been going to court. He went to court almost like 5 or 6 times. He's never missed a court date. He has representation. He is fighting that case, Judge. We're asking for the court on count 1 and 2, $3,500 bond on each count, Judge.
state what the nature of the charges again that he's out on bond on?
Possession of firearm by convicted felon, carry and conceal firearm, and possession of cocaine.
Right, what is that case number?
18-15559 CF10A.
He's been out on bond since when?
Posted bond, he was released December 19th of 2018.
All right, as to the new arrest, I am going to impose a $7,500 bond on each charge at this time. Okay. All right, Al Alvarez Dawson.
Mr. Dawson, come on up, please.
Oh, wait, can I get that paperwork back? Can you get him back?
Oh. He's approaching, Judge.
All right, it is 7,500 on both counts, but with also with a level 2 pretrial supervision. Okay. Alvarez Dawson. Mr. Dawson is before the court with one charge of grand theft auto. Number 2 is operating without a valid driver's license, and I find probable cause.
Judge, can we see if his bond's been posted?
It's not showing that it's been posted.
It will be. Thank you, Judge.
All right. Here's a $1,000 bond. Lorenzo McKinney.
He's approaching, Judge, here at me. Come on up, sir.
Mr. McKinney is before the court on one charge of grand theft auto, and I find probable cause.
Judge, I'm going to be contacting Mr. McKinney's mother to post his monetary bond.
Does Mr. McKinney have any priors?
For 1 moment. 1 moment, Judge. Okay. Right. Showing misdemeanor possession of cannabis, Your Honor.
All right, so he has a $1,000 bond. Robert Des Holmes.
Mr. Sons, come on up, please.
Good morning, Judge.
Good morning, sir. You are before the court on one charge of grand theft auto. Number 2 is possession of MDMA. Number 3 is possession of cannabis, 20 grams or less. Number 4 is driving while license suspended, and I find probable cause.
Judge, it's me, Mr. Des Holmes. Unfortunately, he's not in a position to post a monetary bond. We're going to be asking the court to consider releasing him under pretrial release. Before I proceed, I'll see if the state has an objection.
I do not.
All right, I'll ROR to pretrial. Mr. Des Holmes, you need to report to the pretrial office no later than tomorrow morning. If you don't report, a warrant will be issued for your arrest. And also, well, they open at what time again? At 7:30. Sir,
I'm sorry.
sir, also, you will be subjected to random drug testing. Okay?
Yes, ma'am.
All right. Yes. All right, Marcus Jewell.
Good morning, Your Honor.
Good morning, Mr. Jewell. You're before the court this morning. Charge 1 is possession of an altered firearm. Number 2, carrying a concealed firearm. And number 3, possession of a weapon or ammo by a convicted Florida felon, and I find probable cause.
Judge, it's me, Mr. Joel. He did advise me he has prior contact with the criminal justice system, but he's been about, from what he advised me, 10 years clean. He's 35 years old, been here his whole entire life. He lives in North Lauderdale with him, his girlfriend, and his 5 children. His girlfriend is working. She works at Subway. My understanding is Mr. Joel does landscaping.
Yes.
Right now, from what he advised me, they are having financial problems. There's nothing that they're going to be able to afford. He's asking if the court would consider releasing him under supervision. I do understand the nature of the allegations are serious. If the court's not inclined to release him on standard pretrial release, then we'd be even asking the court to consider a level 2 pretrial.
Most recent history I see, Your Honor, is a 2008 Grand Theft Auto 2008 burglary of a structure, unlawful use of false name ID, 07 grand theft auto.
Right, I'll, ROR to level 2 pretrial supervision. And no weapons or firearms. And sir, you need, well, the pretrial will have to come to you. Okay, Isaiah Tolliver. Mr. Tolliver is before the court. Charge 1 is burglary with assault or battery. Number 2 is petty theft. Number 3 is a felony violation of probation with a no bond hold. And I find probable cause.
Your Honor, on count 1, state would be seeking a finding of proof evident or presumption great, and that Mr. Tolliver be held no bond until further order of the court for first appearance purposes only. Just noting the allegations contained in the affidavit would support the elements of the offense. The allegations made by the juvenile victim were supported by the, she's listed as a victim, also a witness, his mother. One moment, Your Honor.
In light of the no bond hold on count 3, Your Honor, would be reserving any argument regarding proof evident presumption great until such time as Mr. Tolliver can address those issues with his division judge.
Nothing further from the state.
All right, as to account 1, I will make the preliminary finding of proof evident presumption great. He will be held no bond. This is without prejudice, and then he does have a no bond hold on number 3. No bond is required on 2, so I will not impose 1. Okay,
Judge, would you sign photo order as well?
all right.
And Your Honor, I would just request no victim contact. It appears they're neighbors.
No victim contact. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am.
All right. Alex Dubison,
He's a refusal, Your Honor.
Mr. Dubison is a refusal.
Yes, ma'am.
All right, so we'll reset till tomorrow, and then we'll see what happens then.
Your Honor, do you know if the PC determination was made?
On which one? Is this more than a,
I'm showing he was reset from last Friday and the entire weekend.
from last Friday?
That's what it says in the
Yes.
document.
And Judge Powell?
Yes.
Excuse me, I can tell you, I'm going to get he and the next, case healed.
Yeah.
And they late there and they say I'm not going. That's,
All right, so I didn't realize that Dubison is more than a one-time refusal. So Mr. Dubison is facing charges of grand theft auto, carrying a concealed firearm, resisting officer without violence, attaching a registration license plate not assigned. That's, and then he has an out-of-county hold which has a no bond hold and is not from magistrate. So, with that in mind, I will make a find probable cause in absentia, and I'll leave the standard bonds in place, and he does have a no bond out-of-county hold. All right, thank you, Deputy.
you're welcome.
And then Lewis Hill, you say is also a refusal?
Your Honor,
Yes, ma'am.
if I may
And
inquire,
he's-
Deputy, was Hill a refusal over the weekend, or was he medically reset over the weekend, if you know?
He was a refusal as well.
All right, and I have 2 times that he also refused.
And he's on pretrial.
All right, well, he's not before the court, so I can't handle the pretrial matter, but as to the petty theft, that's before the new charge. It's a felony petty theft, I find probable cause, and I'll leave the standard bond of $750 in place. All right? Thank you. And then, last but not least, Mr. Plant, is your case. And that is Vaughn Kinninger.
Yes, Your Honor, thank you.
All right.
Good morning. Good morning, Honor.
Good morning, Mr. Kinninger. You're before the court on a municipal ordinance violation, sir,
Yes.
for trespassing, and I find probable cause.
Yes. May I ask a question?
Yes, sir.
May I resolve it today?
You certainly can. All right, so I'll sentence you to time served. Do you wish to accept that?
Yes, ma'am.
All right, please raise your right hand.
I will.
Do you swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. And
Thank you, ma'am.
do you understand the offer that has been extended to you, sir?
Time served.
Yes. Is anyone
Thank you,
forcing you to resolve your case?
Nobody at all.
Are you under the influence of drugs or alcohol?
I am not, ma'am.
Do you need any more time to speak with your attorney?
I do not.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
My rights are fully understood.
Have you ever been treated for mental or emotional illness?
I have not.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, that would be an issue.
What plea do you wish to enter at this time? Guilty or no contest?
I plead no contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served.
Thank you so much, ma'am.
Good luck, sir.
All right, good luck, sir.
Thank you.
All right, I believe we're at the end of our morning docket. I'll see everyone at 1.